Welcome to Early Returns, hosted by Jan Barron, a partner of Holtzman Vogel. This podcast examines law and politics and seeks insights from political players in elections, lobbying, media, and the law. Now, let's join our host, Jan Barron.
Welcome to Early Returns, a podcast about law and politics. I'm your host, Jan Barron. Russia has launched a war in Ukraine. While the West now focuses on diplomacy and military assistance, many foreign countries, including the combatants, Russia and Ukraine, spent years seeking to influence American politicians and public opinion. There was lobbying about the construction of the Nord Stream 2 pipeline. There were investigations about Russian influence in our elections. There were allegations that foreigners were making campaign contributions. My guest for this episode of Early Returns is David Laufman, a former prosecutor and the former Department of Justice section chief who oversaw national security issues, including export controls, sanctions, and the Foreign Agents Registration Act. David is currently a partner in the law firm Wiggin & Dana. David, welcome to Early Returns.
Thank you, Jan. It's great to be with you.
Now, before we get started on this very interesting topic of how we in the United States regulate foreign activism in politics and propaganda and public relations and lobbying. You are here in Washington currently, but that's not where you started. Just give our listeners a little sense of where you grew up and how you wound up in Washington.
I was born and raised in Houston, Texas. I remain a stalwart and unrepentant Houston Astros fan. I left Houston in 1976 after graduating from St. John's School to attend the University of Pennsylvania in Philadelphia, following in my older brother's footsteps, where I majored in international relations and studied Arabic and was keen to join the government. I was in high school during Watergate and was very politically aware, but keen to work in the area of foreign affairs and national security. And to my good fortune and bewilderment, the Central Intelligence Agency hired me as an all-source analyst, and I began in early 1980 at the tender age of 21 years old to serve as a CIA analyst, working first on military affairs in Southern Africa and then as a political analyst for Near East, South Asia, and was at the agency for several years. It was a wonderful experience, real baptism under fire as a young professional before deciding to leave for law school and begin my legal career.
That gives you an interesting perspective of not only professionally having a lot to do in terms of overseeing foreign influence here in the United States, but apparently you might have had a little bit of perspective on your CIA days of U.S. influence abroad, right?
Well, the spread of democracy, of course, is a core value of the United States of America, for which I was an ardent adherent, yes.
We won't get too much into the weeds on that one, but we do want to talk about all this foreign activity in the United States, obviously in the modern context of how this preceded what we're witnessing today in Europe with really the first war in Europe since World War II. And it is interrelated. And we have here in the United States a long history of concern about what to do about foreign countries coming in here and trying to influence us on our own policies, which we think of as domestic. But of course, it has implications for countries and people who are outside the United States. I like to think that the first piece of evidence of that type of concern was the emoluments clause in the U.S. Constitution. I mean, right from the days of George Washington, the founders expressed a concern that presidents and other government officials should not receive gifts from foreign nations. It's right there in the Constitution. Separate from that, we've had concerns about lobbying and public relations. It seems that that sort of started with the Foreign Agents Registration Act, which was something that you had to administer in your time at the Department of Justice. Where did that come from and how did that start and how does it work?
Well, the Foreign Agents Registration Act, more commonly known as FARA, long predated many federal laws prohibiting campaign contributions directly or indirectly by foreign nationals. This is a law that originated in the mid-1930s, was enacted in 1938 by Congress, specifically in response to both covert and overt activities in the United States by Nazi German proponents and operatives, as well as then Soviet actors. And this essentially is a law aimed at promoting transparency and disclosure regarding the conduct of certain activities in the United States on behalf of foreign governments and other foreign interests. The law does not suppress or control speech or content of speech, but it does require disclosure and registration with the Department of Justice when parties in the United States are acting on behalf of a foreign interest engaged in certain kinds of activities, unless they qualify for one of several exemptions in the law.
That is administered by the Department of Justice. I assume that if you're a foreign agent, you got to register with the department, and then you're going to have to file periodic reports. What is the history of how frequently foreign agents register with the department? It seems that there's been a little bit of an evolution, particularly when you started there at the department.
Well, as you point out, the law is administered by the National Security Division of the Justice Department. The National Security Division, or NSD, arose from the post 9/11 reforms to become the first new litigation division in decades at the department. And within NSD is the counterintelligence and export control section that I led from late 2014 to 2018. And within that section, known as CES, resides the FARA unit, a subunit that daily administers and enforces FARA under the supervision of officials within CES and the National Security Division. There's been an ebb and flow of enforcement of FARA over the decades. There was considerable enforcement in the post-World War II era, mostly focused, I think, on the Soviet threat. Some folks describe a long kind of period of dormancy. In the early 60s and 70s, there were occasional criminal prosecutions of great notoriety, Tongson Park, Korean lobbyists, and others. But there really wasn't a kind of full court press of enforcement until soon after I arrived as chief of CES in late 2014, when, consistent with an overview of all of my enforcement responsibilities, I sought to determine how well we were meeting our enforcement obligations across the sweep of our purview, whether it was the enforcement of U.S. sanctions laws or trade secret theft prosecutions, or in this instance, the Foreign Agents Registration Act. And it quickly became apparent to me that we were not up to snuff in meeting our obligations. And so we began to institute measures to adopt more rigorous enforcement measures, to send administrative inquiries to parties as to whom a question had arisen as to whether they ought to be registered. Sometimes news articles result in those kinds of inquiries, to refer more matters for criminal investigation, and to bring prosecutions, particularly in cases where a party had willfully failed to register and sought to conceal or avoid registration, knowing that they had an obligation to register. And as you point out, there's a number of things that flow from having to register. You had to register within 10 days even of agreeing to do work in the United States in one of these types of covered activities, whether it's influence activities or public relations activities, within 10 days of agreeing to do so, even if you haven't begun performing any duties here. As you mentioned, Jan, every 6 months you have to file a supplemental disclosure statement that goes into great detail about the funds you've received, the expenditures you've made, what types of activities you've performed in the United States. If you're engaged in disseminating content within the United States on behalf of your foreign principal, which is a defined term, you have to include a notice or a conspicuous statement within that content, regardless of the medium through which it is disseminated, expressly, prominently disclosing to the consumer that you're an agent of whatever foreign interest is your foreign interest, and further documents are on file with the Department of Justice. And you have to file copies of that with Justice within 48 hours.
Yeah, let's drill down a little more on this aspect of FARA, which has an interesting recent history. What you're discussing here is the requirement under the law that if you are engaged in disseminating certain content in the form of public communications and advocacy, what loosely but not legally would be referred to as propaganda that's controlled by a foreign country, communication and content. I'm going to let you redefine that in better terms than I have done. But what we're talking about is public communications of certain types will trigger no lobbying, no political activity, but just disseminating content under certain circumstances on behalf of a foreign country triggers an obligation to register and report. How does it apply to specific publications?
One note for your listeners, when we talk about foreign countries or foreign interests, we need to be clear that this is a statute extremely broad in its scope right now. If you are acting within the United States on behalf of a, quote, foreign principal and engaged in one of certain types of activities, then you're going to have an obligation to register unless you come within an exemption. But the term foreign principal is broadly defined not only to include things you might expect, like a foreign government or a foreign political party, the things that go to the very root of this statute back in the 1930s, but expanded over the years to include non-U.S. commercial entities. It could be a foreign non-governmental organization, an NGO, it could be a charitable organization, it could be a think tank, it could be an academic institution, it could be an individual living outside the United States. Any of the things I've just described could come within the definition of a foreign principal, and even in situations that might be ostensibly commercial in nature, where parties might not think that what they're doing could come within the scope of this statute, it is so broad in its application that it causes parties to have to undertake this kind of risk analysis, this legal risk analysis up front, oftentimes before even engaging in a new business transaction or a new business relationship, to try to assess whether they might have to register for that engagement because of all that comes with that. And in many quarters in the United States, there's a kind of perception of stigmatization of having to register. And I've described this as a disclosure and registration statute. There's nothing nefarious on its face with complying with U.S. law. You are complying with U.S. law. Nonetheless, the news media in particular characterize registrants with the Department of Justice as, quote, foreign agents. And many people, individuals and businesses in the United States, just don't want to risk that kind of reputational stigma as they see it, and will often forego business transactions or relationships that they think may subject them to potential FARA registration. So the statute has come to have an exceedingly broad scope of application, which is one reason why this ABA task force we may talk about was set up and was one of the features of some of our recommendations for reform.
Yeah, and we'll get to that. And you're touching on the breadth of who is a foreign principal. But even once there is a categorization of a foreign principal, if it is, for example, a foreign-based commercial corporation that may not be owned or controlled by a state or political party, there are provisions in the law that would allow that foreign company to avoid having to register under FARA by, for example, registering under what we call the Lobbying Disclosure Act, which is the general lobbying law here in the United States that applies to everybody, unless, of course, they're disseminating public information and advocacy, perhaps.
Right. So among the exemption under FARA is if a party is lobbying Congress on behalf of an ostensibly commercial entity, they can forego FARA registration as long as they register with the House and Senate under the Lobbying Disclosure Act. But that option is not available if they're lobbying on behalf of a foreign government or foreign political party. In that instance, they would have to register under FARA.
Well, taking in the United States provision and putting it in practical application, particularly for Russia, there may be people who are unaware of the extensive communications apparatus that Russia had established in the United States. Russia Today was a print insert that appeared in certain daily newspapers like the Washington Post. I remember receiving something called Russia Today as a section in the Washington Post when I used to subscribe to its dead tree format and have it delivered in the morning. I think it showed up every Wednesday. RT and Sputnik are television and radio programming that actually is established in the United States and is broadcast and disseminated within the United States. That's, by the way, not entirely unusual or unique. I mean, we have other foreign countries that have controlled communications or certainly influenced communications operations, foreign press, foreign broadcasters, whether it's the Canadian Broadcasting Company or the BBC or Nippon News, they can be here. But it was the Russians that seemed to have triggered the interest in renewed application of FARA. to a foreign-controlled communications apparatus here in the United States. And I think you were part of that, weren't you?
Yes, under my tenure, among the early kind of path-blazing enforcement actions we took was to require registration under FARA with the Department of Justice by RT-TV, America, as it was known at the time, and by RIA Global, which was a corporate entity associated with Sputnik. And on the Department of Justice's website, under the FARA unit's website, you can find lengthy letters that we sent to counsel for RT-TV and RIA Global, laying out meticulous factual background and legal analysis and reasoning as to why we determined that they were agents of a foreign principal with an obligation to register under FARA. And that analysis involved, among other things, a careful review of contractual documents, making clear that parent Russian state-owned media, known to be under the control of the Kremlin, exercised editorial discretion or control. And that, combined with a number of other factors, including the complete alignment of messaging by these US-based apparatuses that were extensions of Russian state media, were completely parroting Russian government propaganda. Nonetheless, the consequence of requiring them to register was not to suppress their broadcasting or speech or content. It was simply to require them to register. And as we discussed earlier, to include a broadcast conspicuous statement at certain prescribed junctures of their broadcast, making clear to their listeners, in essence, that you're listening to Russian propaganda. Do with it as you wish.
Did anything change at RT or Sputnik once they registered and filed reports? I mean, other than they had these notices, was the propaganda continuing to be disseminated in the same fashion?
To my knowledge, nothing changed with respect to the nature or content of their programming, and that's not the purview of the Foreign Agents Registration Act. It could be the purview of other legal or regulatory regimes, but that's not what FARA is about. The whole idea, of course, is to put the American consumer of content in the position of being able to have full understanding and visibility that the content they are consuming is being devised and disseminated on behalf of a foreign interest. So the consumer, he or she, can assign whatever weight they want to that factor, but they know now that what they're consuming may have to be taken with a grain or two of salt, or in the Russians' case, half a barrel of salt, in evaluating what weight to attach to it.
How does this work, if it does, with electronic media, internet-based media, social platforms? Obviously, a social platform like Facebook is not foreign control, but is used by foreign actors to disseminate their message. Are there circumstances where there would be a trigger under FARA that would require somebody to register and file reports?
It could be. These are very fact-dependent inquiries. One fact to the left, one fact to the right can alter the Department of Justice calculus of whether a FARA registration obligation obtains. Is U.S. computer being used to disseminate messages? Where are the actors devising and disseminating this content? What role, if any, do foreign governments have in devising this content? This conspicuous statement requirement that I've described does apply to social media. Needless to say, social media did not exist in 1938. The Department of Justice, only several weeks ago, in announcing its plans for potential regulatory reform, acknowledged that numerous new communications technologies have come that require fresh thinking about how to put American consumers of content on notice. That's going to include figuring out how to devise these conspicuous statements on social media, whether it's a tweet or something else, a web-based platform. This is kind of a new frontier of FARA enforcement that the Department of Justice is thinking through and eliciting comments about.
Well, in my introduction, I referred to Nord Stream 2 pipeline, which was the gas pipeline that has been almost completely built, I think, taking Russian gas to Europe through a pipeline, mostly for the benefit of Germany and certain Northern European countries. That ostensibly is a commercial type project, but actually it's primarily financed by foreign countries. Russia principally, but Germany and Sweden and some other countries were very, very active in supporting the construction of that pipeline. And of course, it became quite controversial recently in terms of whether it would be subject to sanctions, pipeline itself. And once the war in Ukraine started, all of a sudden there were news reports that several U.S.-based lobbyists deregistered under FARA. We may not have known that they were registered in the first place, but they were registered because they were representing the interests of these foreign governments in that particular project. And they were lobbying, apparently, primarily the White House. Even before the war started, there was an issue for President Biden as to whether the U.S. government would sanction the pipeline itself. That seems to be a very significant episode in FARA. Is there some other nuance that we should be aware of? I mean, what does that all mean? You know, that there's regular registration of lobbyists for foreign governments who are trying to influence not just Congress, but the White House, the president, the senior staff of the White House. How does that all work?
Well, there's nothing new under the sun about foreign interests through their American contractors or lobbying firms or law firms trying to influence the White House, the executive office of the president, national security officials, as well as House and Senate committees and staff or U.S. government agencies. You know, the parties you described who were registered under FARA were probably doing precisely what they should have been doing. They were registered. They disclosed their affiliations with the foreign parties whose interests they were serving in the United States. They were above board. They presumably were meeting their disclosure obligations. But then Ukraine happened. Then this barbaric, totalitarian savagery in Ukraine occurred. And many of them, I think, felt that the reputation hit of continuing to be associated with Nord Stream was just too steep a price to pay. And I think some of the exits from these engagements seen in the terminations of these registrations was a matter of mitigating reputation risk. In other respects, they may have been concerned about being on the wrong side of new U.S. sanctions being imposed, or some combination of those things. And that's why you saw, I think, a rush to the exits by a number of parties who were registered in connection with their work on behalf of Nord Stream.
Well, you know, and the reverse occurred with respect to Ukraine after the collapse of the prior government back in 2014. We discovered subsequently, perhaps in large part because of the reputation and notoriety that was attached to Paul Manafort, that there seemed to have been a lot of lobbying on behalf of Ukraine that was not registered under FARA and subject to disclosure. And I think one of the more controversial elements, I say controversial in the sense that people disagreed on the legal interpretation, is where lobbyists here in Washington, D.C. were doing certain lobbying ostensibly on behalf of a nonprofit that was headquartered in Brussels. And as a result, they didn't register under FARA because it was a nonprofit and arguably not controlled by a foreign country, but they registered under the Lobbying Disclosure Act. And subsequently, it was revealed through other investigations that this nonprofit was almost entirely, if not entirely, funded by the political party in Ukraine and was controlled by their representatives, which included Paul Manafort. So how often does the Department of Justice actually wind up getting disclosures handed on a plate here as a result of unrelated investigations that reveal that, number one, there's some lobbying going on that should have been subject to the FARA disclosure. Number two, there's a controversy over the facts. These lobbyists genuinely thought that they were exempt from FARA and, in fact, registered under the Lobbying Disclosure Act, but nonetheless found themselves in this predicament of legal compliance.
Well, in my experience, it rarely happens that the parties in the United States who have registered in the reasonable good faith belief that they come within the scope of some provision of the statute that enables them to register with Congress under the LDA, or not to have to register at all or qualify for some exemption, that they believe in good faith there's a set of facts that supports their posture toward registration. In this case, it was a complete sham. As you point out, this Brussels-based NGO was just a shell instrument created to create a story that the Ukrainian government or Ukrainian government officials were not the real parties in interest. And the concealment of that was at the heart of the criminal prosecution of Mr. Manafort It also had other tentacles in which prominent U.S. law firm, Skadden Arps, became entangled. They were involved in helping to devise a report to present Ukraine view in a more favorable light in U.S. public opinion. Skadden wound up paying a criminal penalty of more than $4 million, reflecting the fees it had earned in that engagement, had to institute a major new remedial compliance program there. And it was really a petri dish of somewhat unique factors where a nefarious conspiracy was devised to conceal the hidden hand of a foreign government in an influence campaign in the United States. And nothing goes more to the heart of FARA than a set of facts like that. And it was unsurprising that we elected to pursue criminal prosecution in that case, in addition to FARA registration. Mr. Manafort, at our behest, did wind up registering, but there were some statements and omissions in connection with his registration that also became the subject of a later criminal prosecution.
Well, what is likely to be the future, both in terms of enforcement and the statute? You mentioned the fact that, number one, was an ABA task force, which you co-chaired, examining FARA and then drafting and filing a report that was sent to the Department of Justice about suggested improvements or changes or reforms in FARA. And your report had sufficient influence at the Department of Justice that they actually initiated a rulemaking for the first time, seeking public comment and input on what might be useful in changing as a rulemaking matter. Of course, the Department of Justice, like any executive branch agency, doesn't have the power to rewrite the law to the extent that something needs to change because of the law itself. That would be something that Congress would have to do. So what do you think is going to happen? And of course, more importantly, what do you think are the top 2 or 3 reforms that might be necessary for FARA?
Well, it was gratifying to see the hard work of the ABA task force that I co-chaired pay off after 2 years of really intensive, careful, methodical consideration of potential reforms and what to concentrate and prioritize on. It is an extraordinary advance notice of rulemaking that the department issued, which they submitted multiple questions for people to respond to, signaling the areas where they're receptive to utilizing their regulatory rulemaking. There's some things the Department of Justice can do on its own without the need for a rulemaking or acts of Congress. They can provide much more robust policy guidance, as they have started to do, white papers that they have published on their website, publishing more advisory opinions that they issue to people seeking guidance on whether something may require registration. Others require changes to the law, whether it's statutory changes, which require congressional action and the president's signature, or regulatory action. We engaged in a kind of soup to nuts, comprehensive review of every facet of FARA that we thought merited reform. And some of those will require acts of Congress. We even recommended that they change the name of the statute so that foreign agent isn't in the name, so it's less stigmatizing. We recommended that the breadth of the definition of foreign principal be narrowed to the historical roots of the statute to focus on foreign governments, foreign political parties, and individuals or entities in the United States acting on their behalf. Some of those types of reforms will require acts of Congress. We do know that FARA reform legislation was on the drawing board of the Senate Foreign Relations Committee, which has jurisdiction over FARA in the Senate. We thought it was moving toward potential hearings, but then Ukraine happened, and it's hard to know when attention will return to FARA. There are recommendations we made for the Department of Justice to provide better clarifying guidance about terms that are quite vague. This commercial exemption you describe, or when actors in the United States are acting on behalf of ostensibly foreign commercial or foreign non-governmental entities, those exemptions are not available if the activities in the United States, quote, directly promote the public or political interests of a foreign government or foreign political party. Well, the term directly promotes is nowhere defined in statute or regulation and can be understood only in terms of the various multiple advisory opinions laid side by side across a large room. There's no unifying policy guidance. There's no statutory or regulatory definition. So there's a great need for more interpretive guidance by the Department of Justice, some of which they can do simply through white papers or public guidance. Others will require some regulatory change. So too, with respect to the Lobbying Disclosure Act that you described, as we've said, the exemption that enables people lobbying Congress to register under the less disclosure requiring LDA, then FARA is not available if the, quote, principal beneficiary of that lobbying work is a foreign government or foreign political party. Well, what does principal beneficiary mean? It's nowhere defined in law. So these are just some examples of things that will benefit from either statutory correction or regulatory reform. And we'll have to see where this goes. But I do think it is historical, noteworthy event, as you point out, that the department has begun this rulemaking process. We'll see what comes from it, but I think we're going to see some improvement.
There's a certain tension, it seems to me, about how we're going to regulate foreign government influence in the United States. But at the same time, we have to, for diplomatic reasons and international law reasons, be very careful about not regulating the actual physical presence of the foreign country in the form of their diplomats and their embassies here in the United States. Russia may have created an interesting communications powerhouse here in the United States, but they probably have 200 employees over at their embassy in downtown Washington, D.C., and engage in a broad area of influence through the embassy, influencing the government, influencing public opinion. How does FARA recognize and accommodate all that? Can the embassy engage in propaganda and that's okay and doesn't require registration disclosure? But if they have a separate private corporation doing broadcast, that corporation has to register?
Foreign embassies, consular officials are all exempt under FARA, even visiting foreign government dignitaries coming in, say, for the UN General Assembly meetings in New York, they're all exempt. FARA has nothing to do with them. If they're engaged in the theft of classified information from U.S. government agencies or personnel, they may be running afoul of espionage laws. If they're stealing trade secrets or proprietary intellectual property, they could be running afoul of trade secret and economic espionage laws. We have other tools to deal with malign foreign behavior within the United States. FARA doesn't really address that conduct. On the other hand, if a foreign embassy is using some kind of ostensibly commercial cutout in the United States to propagate content on behalf of a foreign government, that commercial entity then is almost certainly going to have a FARA registration and have to disclose what they're doing and on whose behalf. So ultimately, there could be some disclosure by the actor retained by a foreign government in the United States, even if the foreign government itself doesn't have a registration obligation under FARA.
One last question before we wrap things up. If you know, David, how do the Chinese operate compared to the Russians here in the United States?
Well, it depends what you're asking about. As the FBI director, a former colleague of mine, Chris Wray, has testified recently, the FBI is opening up a new case on China about every 12 minutes. I had hundreds of counterintelligence cases on my docket. It was a steady drumbeat, a battle rhythm of incoming counterintelligence cases. The vast majority of them were China facing. The Chinese threat to U.S. national security and economic security here in the United States is relentless. It is pervasive, and it is aimed principally at stealing technology and secrets pursuant to their express economic modernization plan to enable them to make strides in their own economic modernization in key industries that are core to that economic modernization. So it's on a completely different scale than the types of intelligence threats we face from the Russians, which are quite significant, but of a different nature for the most part.
And do the Chinese have a communications operation here in the United States like Russia Today or Sputnik?
Well, there's a media organization by the name of Xinhua that was also required to register not too long ago, similar to what we required of RT-TV and Sputnik's affiliate here. You mentioned getting in your hard copy Washington Post in days of your RT supplement. In my neck of Northern Virginia, we often get a supplement for China Daily. If you were to look at the bottom of the first page, the front page of the supplement, you would see this conspicuous statement I described that China Daily is an agent of such and records are on file with the Department of Justice.
Our discussion on FARA and these types of communications programs is in addition to what might be going on with respect to direct attempts to influence campaigns for public office, and the separate campaign finance laws actually prohibit making any contributions to candidates. By the way, at any level of American politics, it's one of the few laws that prohibits campaign contributions at any level of American politics. For Congress, president, governor, legislator, dog catcher, a foreign national, which is defined in the law as somebody who's a citizen of another country or has its own operations abroad, as well as foreign nations, cannot make contributions to any of these campaigns. And so there's a tension here between a law that prohibits certain forms of influence and another law that doesn't prohibit it, but does require certain registration and reporting and disclosure. David, thank you so much for that insight and up-to-date information. As I try to do with my guests before we formally sign off, is to try and see what else they might have to share with our listeners that may or may not be relevant to anything we've discussed up to this point. And in particular, what, if anything, are you reading or any books that you might recommend for our listeners?
Well, I try to divorce my pleasure reading from my professional pursuits. I have rather Catholic reading interests. I try to keep some good fiction going alongside some good nonfiction. Right now, I'm reading a fascinating biography of Mike Nichols, the acclaimed former film director and theater director. It's called Mike Nichols, A Life by Mark Harris. It's really quite excellent. I'm reading a novel by one of my favorite authors, Michael Ondaatje, who was the author of The English Patient, called Divisa Darrow, that I highly commend to your listeners. And then for fun, I'm reading this new history of the making of The Godfather, which is just one wild ride, called Leave the Gun, Take the Cannoli by the author Mark Seal, which ought to be on everybody's nightstand now because it's a nice tonic from today's headlines and a lot of fun to read.
Well, thank you for those suggestions, and they all sound very interesting. And thank you for joining us here on Early Returns. Appreciate it very much. And we look forward to the next episode, which will come up shortly with another guest who I hope will be as informative and insightful as you have been. Thank you, David.
Thank you, Jan. Thanks so much.
Thanks for joining Early Returns, Law and Politics with Jan Barron. We hope you will join us for future episodes, which will continue to bring you voices and insights from the people engaged in our political landscape.